There's also a box just to the right of the question box called web links, and these are resources our presenters today may be referencing in the presentation. We have live captioning as well as our ASL interpreter on screen, and our presenters will be by audio only. I'll go ahead and turn it over to Peter Hoffer, who is our moderator for today's event. Peter?
Hi, thanks, Matt. Thanks, everyone, for joining us today. This is Peter Hoffer. I'm a senior litigation attorney here at Disability Rights Texas. Over the past 17 years or so, I've represented about 250 children in Medicaid appeals. I've also litigated several federal lawsuits against Texas Medicaid. So all of us presenting have experience with children's Medicaid appeals. I'm joined by Terry Anstey, another one of our healthcare lawyers. Terry is also a registered nurse, so he brings additional valuable perspective to the issues we're going to discuss today. And Hillary Garcia, she's another one of our healthcare attorneys, and she just represents children in Medicaid appeals. Before we get started, I want to say that I know these are very anxious and frustrating times for parents and families of kids with disabilities with everything that Texas Medicaid is doing through managed care. We're going to be discussing how to prepare for a fair hearing. We're going to try to give you tools to help you do the best job you can in representing your child. It's sort of a general presentation, but we will have separate slides on if it's an MDCP denial or if it's a private duty nursing denial. I wish we didn't have to have this presentation. I wish there were not so many denials and reductions in services. I also wish that we had more attorneys that could represent all the children who need representation. But there's only 4 of us that do children's Medicaid cases here at Disability Rights Texas. More than that every week in cases. So we wanted to do something to give parents some tools, some information they can use if they have to represent their children themselves. So with that, we'll get started. If we don't answer everyone's questions, we'll probably save them to the end to make sure we get through the presentation. If we don't get to everyone's question, there'll be a Q&A email sent out where we will try to answer all the questions in writing later. There's also going to be some other materials available, a checklist for preparing for a fair hearing, and some other sample letters, sample documents that Terry's put together. So those will also be available. So with that, we'll get started, and I'll turn it over to Terry and Hillary.
Okay, great. Hi, this is Hillary. We're going to start first with the due process protections for Medicaid beneficiaries. I would like to point out when we begin with this slide that we will get in a little bit further in depth within the webinar about many of these due process protections. So that's just a brief disclaimer. So there is the right to have a fair hearing at a reasonable time, date, or place. As we'll discuss further, parents do have the option to request a continuance. A big thing for me on this slide particularly is the case file. Most time parents will receive the evidence packet and might not notice that within the actual letter with their appeal rights, they have that notification of their right to request the case file itself. The case file and the evidence packet are 2 separate documents, and we'll discuss that a little bit further. But you do have the right to request and review the case file prior to the fair hearing. Okay. Next slide. Also at the fair hearing, you have the right to bring witnesses, establish the facts as pertaining to your child's case, and present an argument without undue interference. Also, you have the right to cross-examine adverse witnesses. And cross-examination may seem intimidating for a lot of parents or scary in terms of what types of questions they should ask. But I would say, having talked with many parents and preparing them through the fair hearing process, that you are prepared and do have adequate questions to ask during cross-examination, because when we're preparing for that particular process with parents, they bring up a lot of issues that if they would have been doing this on their own, they were absolutely valid questions that they should raise on cross-examination. And something big also on this slide is the submitting the evidence before, during, or after the hearing. So although we will talk about preparing the evidence packet, you do have the opportunity to ask that the fair hearing be kept, or the actual record to be kept open, so that you can submit documentation after the fair hearing itself has concluded. So you can submit that information to the fair hearing officer. Again, I wanted to emphasize that particular point because sometimes when you proceed to fair hearing, you might not have all the documentation, or you might have received it a couple days before without having time to submit it to the fair hearing officer. And if you address that particular document during the fair hearing, you should also have the opportunity to submit that to the fair hearing officer so she can review that documentation before he or she makes their decision.
This is Peter. I would also add the present an argument without undue interference. I have listened to some recordings of hearings where parents did represent their children by themselves, and sometimes the hearing officers will rush parents, or the agency representatives will interrupt them and try to rush them. Again, you have the right to present your case without interference, and just remind them of that if they start interrupting or trying to rush you through the hearing.
This is Terry. I'll take the next slide. There is a lot that needs to go into a denial notice of services or a waiver program like the Medically Dependent Children Program, or MDCP. Some of that information, first, the letter has to be sent out 10 days before the proposed action date. Sometimes it's sent before, way before that, and sometimes it's not. The information that needs to be in that denial notice also is the date that the fair hearing must be requested to receive continued services, and also how many days before you don't have the right to a fair hearing anymore. The number that you can call to request that fair hearing, the letter also has to say that you can, you or somebody else, it doesn't have to be a lawyer, can represent your child in a fair hearing. Also, it talks about that you have the right to examine the information before the fair hearing to determine how the agency came up with their denial decision, and the circumstances under which you can have the services will be continued. You can have continued services during the fair hearing process. The theory behind the 10-day appealing within 10 days to receive continued services is that the agency has to send the denial notice 10 days before the proposed action. So if you appeal before the proposed action date, then you stay that action. You prevent that action from happening. So that's why you are able to receive continued services pending the fair hearing outcome. In the next slide. These, denial notice, sometimes you have a denial notice that says a request for a certain service was incomplete. This happens sometimes with therapies denials like PT, OT, or ST, or private duty nursing. They have to also, some denials they have to state the basis for their denial action, and they have to explain what policy they use that allegedly supports that denial action. For incomplete requests, I like to add that it may be futile to request a fair hearing and go to fair hearing on an incomplete request. It's going to be difficult to argue in a fair hearing that the denial was incorrect if the request for the service was incomplete. It may save time to just re-request services rather than go through the fair hearing process and not have the services that were requested. On the second point, it's important that you get the information about why something was denied, the basis for that denial and the regulation, so that you can test out to determine whether the agency was actually right or wrong, determine what box that the agency has to stay in during the fair hearing, what they have to prove, and the reasons and the regulations are important for the hearings officer to examine. If there's nothing there, then there's nothing to test, and there's nothing that the hearing officer can look at to determine whether the agency was right or wrong. Next slide.
This is Peter. I just wanted to mention, you talked about, Terry, the 10-day notice and getting continued services, which is vital for kids. I wanted to make sure parents understood. You should go ahead, and our advice is always to ask for the fair hearing, ask for the appeal, ask for your continued services within those 10 days. You can always withdraw your hearing prior to the hearing date or even at the hearing with no penalty. But if you miss the 10-day window, you won't get your services continued. And the appeal process can take 3 or 4 months. So that's 3 or 4 months you'd be going without services, even if you win. So our advice is always to appeal, ask for continued services, and that gives you time to make a decision if you want to go ahead and go through with the hearing or not.
All right. The next slide is about insufficient denial notices. There are denial notices that don't comply with law or don't have the necessary information. There are some denial notices that don't bother to give you the reasons for the denial and the regulations that support it. If a denial just says that something's not medically necessary without further explanation, then that doesn't give you what you need to figure out why something was denied. Another example of that is fails to meet prior authorization criteria. That doesn't tell you what part of the criteria. There may be 5, 6 different points in that criteria. If you don't know which point is the focus of the denial, then you can't really figure out why something was denied. Some notices don't state the time limit for requesting a fair hearing. That's important information for individuals. And if that's not there, then people will be confused on whether they can ask for a fair hearing or what the deadline is for asking for that appeal or fair hearing. And some notices don't tell you how to request a fair hearing. So that could be a roadblock to getting to a fair hearing. Let's see. Yes,
Terry, if you get a notice that just is medically necessary or fails to meet eligibility criteria, that's something the parents should raise with the hearing officer.
That's correct. And, they can bring that up to the hearings officer. Like at the beginning of a fair hearing, they can ask for a special pre-hearing conference before the main part of the fair hearing in order to bring that up, because first the parents aren't able to figure out why something was denied. If you can't figure that out, then it's really difficult to actually prepare for a fair hearing and know how to combat something that you don't know what the reasons were for the denial. And then the fair hearing officer may agree with you on that point, may ask the agency to redo their denial notice and reschedule the hearing for another date while the agency clarifies that, so you can better understand the denial. The hearings officer can better understand the denial, and you can more adequately prepare for your child's fair hearing.
Okay, so MDCP has a different process in terms of the amount of letters you will be receiving. So initially you'll receive this pending denial letter. It grants the parents and the primary care physician the opportunity to provide additional information. There's not really an obligation for parents or the primary care physician to submit information during this period, but it does not hurt for you to contact the primary care physician and see if you can send in information during this pending period. The primary care physician will receive a letter, just like you did, of the 14-day time frame to submit documentation. Now, 14 days is not a long time, so if you do request information and you receive it after that 14-day window, if you get another letter stating that your child is now denied, so the final denial letter, you can always use that as your evidence at fair hearing. So again, it's not really a big deal if you don't meet that 14-day window. It certainly would help, but there's also the opportunity for them to continue to deny versus actually approving. But there is that option. So you could get a MN approved, which means TMHP would overturn their denial. Next slide, please. So there might be issues with the denial notice itself in terms of you will receive a final letter from TMHP if the services, if they actually agree that the decision should still remain denied, but that letter does not have your appeal rights. It'll tell you that you would be receiving a letter from the program support unit. Now, we have heard from parents that there's the issue with PSU never sending the letter, so they never have the opportunity to request the fair hearing. And that is something that we've heard, so it does occur, but it also often does not. So you will receive your final denial letter, and then you should receive within 2 business days the actual letter from PSU with the information on how to request your fair hearing.
Now, when it comes to denials from either traditional Medicaid or fee-for-service or managed care organizations, there is internal appeal and fair hearing. And in the past, parents were able to skip over an internal appeal, which is an appeal process within the managed care organization. It's a partial proceeding, or the fair hearing, which is the impartial proceeding with a HHSC fair hearings officer. You used to be able to skip over the internal appeal, go straight to a fair hearing. But the laws have changed, and now you have to exhaust your internal appeal before you can get to a Medicaid fair hearing. The internal appeal, it's sometimes successful. It's really, like I said, it's a partial proceeding. That the managed care organization is the one looking at their denial decision again. It's usually a different medical director that is looking at it, but they're pretty much usually going to rubber stamp what the other medical director did. I have seen some internal appeal process be successful, but it's not typical. You also have to, request your internal appeal within 10 days in order to have continued services during that process. And then if an internal appeal is denied, you still have to, again, within 10 days, request a Medicaid fair hearing in order to have continued services throughout the fair hearing process. Some more information about internal appeal. The internal appeal is not really going to generate an evidence packet like a fair hearing request does. Normally, sometimes it's a phone call with a parent or a service coordinator at a managed care organization will call the parent and maybe get a statement. Sometimes I've heard that there isn't any call at all, or the parents don't have any opportunity to provide any information, and that the medical director is just looking at the information again and making a decision on whether they were right the first time. Again, after you get the determination if it's a denial on the internal appeal, then you can ask for the Medicaid fair hearing. Normally it's 2 separate forms that you'll get with your original denial letter on how to ask for an appeal and then how to ask for a Medicaid fair hearing. There's either 2 different processes or 2 different forms. That can be sometimes confusing for parents because appeal and fair hearing, they seem interchangeable. But when they say appeal, it usually means internal appeal, and a state fair hearing or Medicaid fair hearing is that fair hearing process. We advise you to have all of that filled out and ready to go, so as soon as you get an internal appeal decision that may be a denial again, then you're ready to ask for that Medicaid fair hearing.
Okay, so there's multiple ways that you can request a fair hearing. What we encourage is that if you are going to contact the number provided to orally request a fair hearing, that you have documentation of who you spoke with, the date and time of the call. That way, if there's any issues concerning when you actually made the request, you have that documentation. The same with when you mail in a request, we ask that you get tracking. That way, there's that opportunity that if there's any issues concerning, well, you might have been outside of that 10-day window for continuation of services, which is vitally important. You have something to say, well, according to this, I sent it in on this date, which was within that 10-day window. So you definitely want to make sure that there's some way that you can show proof of when you actually made your request for fair hearing. And also when you request the fair hearing, it does not hurt to also state either orally or in writing that you are asking for continuation of services. For MDCP, there's usually the form that you can fill out that they'll send. You can also call in and request the fair hearing as well. So once that PSU letter has been received with the information on requesting a fair hearing, when you make that request, they have to refer it to HHSC, which is the Texas Health and Human Services Commission, within 5 days. So that kind of helps with the timeline of determining when you should, or when your request should be processed by HHSC. There has been issues where when you request it with PSU, they don't refer it to HHSC. So that is just something to be aware of, that might be happening if you haven't received your notice of fair hearing yet.
This is Peter. The reason we stress making sure you keep track of who you talk to, when you talk to them, when you requested the fair hearing, or when you sent something in. We've had a few cases already this year where the managed care entity was not providing continued services and claimed that the appeal wasn't requested timely, and we were able to show that it was, and the continued services were reinstated. So because you request the hearing from the managed care entity, who then relays it to HHSC appeals, there's opportunity for them to sort of drop the handoff or to not follow through on your request. And so if you can say, I talked to this person at 5 o'clock on Monday the 1st, it's helpful establishing that you did indeed request your appeal timely and that you should be getting continued services. You know, you've all dealt with Medicaid for a long time, so you can imagine there's lots of opportunities for there to be mistakes. And so it's better to protect yourself so that you can prove that you did request the continuation of services and appeal within the 10 days.
Okay, so pre-hearing processes before you continue to the fair hearing, something that I want to stress is continuances. So I know for a lot of parents, when they initially contact us, it might be that they're within a couple days of their fair hearing. So we won't have time to review all of the documentation. So we ask that they ask for a continuance. But we often get, you know, the feeling that parents will be timid to ask for more time. But as mentioned, you have that right, and to make sure you have all the information. So when I stress the case file, sometimes parents will receive the evidence packet, will request the case file, but won't receive it. So you do have a valid request for a continuance because you don't have that information. And without that information, you can't adequately prepare for the fair hearing. So you do have a basis to ask for additional time until you receive that information and have the opportunity to review it. You also have the right to ask for in-person hearing. I think the only caveat is that it will be based on the fair hearing officer to determine if you have a valid reason to request it. Most often they believe there has to be a communication barrier. in order to grant that in-person hearing. But sometimes parents think it's a good idea for their child to be seen, and that's why they might consider making that request. Or if again, kind of going back, the interpreter or translator might be another reason, you would need to bring that to the fair hearing officer before fair hearing.
This is Peter, I wanted to answer a couple questions. And again, we'll answer all your questions either at the end or in writing, but there were a couple on, one asked, could you call HHSC Appeals directly to request a fair hearing? No, that's just not the system. You have to call the number that's provided that goes to the MCO, and then they relay it to HHSC Appeals. But you did identify, it is a wonder to me why they just don't have you request your hearing with the Appeals Division, but they do not do it that way. And then there was another question about getting denials for therapy but not getting a denial notice. No, that is not lawful. Providing the information to the provider is insufficient. It's the beneficiary, your child, who has the right, has the due process rights, and has the right to notice. Providers, though, you'll learn, in nursing cases or therapy or DME cases, they usually get the notice first because they're requesting the service, and they communicate with Medicaid by fax. So they get a fax, and they know that something's being denied or reduced, and then you get something in the mail a few days later. So typically parents hear about an impending reduction or denial from their provider, and then they need to wait a few days to get the notice. If you never get a notice, then that's certainly something you probably need to call us about to get fixed, because we'd have to call the Appeals Division and explain that services have been denied and no notice was provided, and therefore you lost your opportunity to appeal and you lost your opportunity for continued services. Yes, continuances. I know I talked to a parent the other day who said, well, we're asking for a second continuance. Is that going to make the hearing officer think our case isn't as good? No. We ask for continuances all the time. Sometimes we cannot get the case file, which we're going to talk about what is the case file, but I've had cases where I just could not get the case file from the agency, and I asked for 6 or 7 continuances because I cannot go ahead with a hearing and make it a fair hearing if I don't have all the documents that I'm entitled to. So if you need a continuance because of the scheduling, a doctor, you need more time to gather additional medical information, your child has a surgery, those are all good cause reasons to ask for a continuance, so don't be shy about it. They typically give the first one almost automatically for the reason that you need the case file or you need additional time to prepare. The more you get, the harder it is to get them because they do want to get the hearing held.
So the first step, you will receive your notice of fair hearing, and I would like to say that usually parents will just focus on the first page that gives them the hearing officer, the date and time, and something that's really important is the fair hearing summary. So you'll get this small packet of information, and the fair hearing summary will show, they'll have questions on when you made the appeal and when the actual action that is being either reduced or denied was to take place, and that's how they'll determine if your child has continuation of services. So if that date is incorrect, or if the box is incorrectly placed as no, your child is not entitled to continuation of services, then you'll have that issue that you can address as soon as you receive that fair hearing notice. So rather than waiting until either your nursing agency or you receive verification that they're going to go off of the reduced number of hours, if it's nursing, or visits, if it's therapy, you can kind of get ahead of that if you know on that form that there is an issue that you can address. But also, after you get that information, you should receive a copy of the evidence packet, which will include all the exhibits, policies, and regulations that Texas Medicaid utilized to make their determination, whether it's a denial or a reduction of services. something that is big is the Phoenix notes or the eternal notes. So we've mentioned that the denial notices can be inadequate, they can be vague, or just state lack of medical necessity. There's not a way for you to determine exactly why they made their decision, but the Phoenix notes might help a little in determining just what the medical directors looked at or what they relied upon in making their determination. And that can help as you prepare for fair hearing.
All right. There sometimes can be issues with the actual evidence packet that you in some cases don't receive in a timely manner. Sometimes people or parents are not receiving it at all before a fair hearing date, or they're receiving it within, maybe just a short period of time before the fair hearing, like a week or a few days. That's happened a few times recently with some of my clients. If a fair hearing packet is not received before the fair hearing, you still need to call in to the hearing at the scheduled date and time and tell the hearings officer that you never received it. That way they can reschedule the hearing to allow the Texas Medicaid to send you that packet like they were supposed to. If you received it like a week or a few days in advance and that's still not enough time for you to prepare for your child's fair hearing, that's another good reason to ask for the fair hearing to be rescheduled. And if the denial notice, if that's not good enough, without the information that they received, you won't even be able to get that help from the internal notes that Hillary just mentioned to determine, how they came up with the denial decision or reduction decision. Let me stress, never miss a Medicaid fair hearing. If it's scheduled and you have to call into the fair hearing, okay, don't miss it and assume without confirmation that fair hearing's been rescheduled. Always call in unless you hear otherwise from the fair hearing office. And don't be afraid to request those continuances. I think we're stressing that pretty well. If you feel like that you need more time to gather information and prepare for your child's fair hearing, don't be afraid to ask for that. All right, there could be issues with the case file as well. Now, the case file is all the information that's going to be in your child's case file for Texas Medicaid, not just related to the reduction or denial in services that you're fighting with Texas Medicaid about. Now, the case file is not the evidence packet. The evidence packet is specific to the issue that you're going to be dealing with at the fair hearing. But you can ask the managed care organization for the case file. Usually you ask the hearings officer for it, and then the hearings officer gets with the managed care organization and asks the managed care organization to send you the case file. The MCO has to prepare that and send it to you. It might be kind of long depending on how much, how long your child's been in Medicaid, what kind of services they've utilized. You want to go through all of those documents. You go through that case file and determine if there's anything in that case file that you may be able to utilize in your own hearing packet that you're going to put together for your side of the fair hearing. Now, in reviewing the evidence packet, the information, it's going to have some documents that you may have already looked at, the information from the nursing or therapy or DME provider. Like Hillary was saying, look at those internal notes written by the managed care organization to determine, how they came up with their decision. Are they transparent in how they got to their denial decision or the reduction decision? Make sure you highlight all the names of the individuals, the players, the medical directors, the nurses. Determine, when they did certain things. If like in a private duty nursing case, they're supposed to, notify your doctor. The managed care organization's medical director is supposed to talk with your doctor before they make a denial decision. Did they do that? And if they did they do it after they already made a denial decision? Or did they do it before? Did they call them and then not give them an adequate amount of time to call them back in order to have like a peer-to-peer call? That's important information that you can bring up during a fair hearing.
Terry, I wanted to mention a couple more things between the evidence packet and the case file. So the case file, again, that's a bigger set of documents than the fair hearing evidence packet. I think another way for y'all to think about the evidence packet that you get from the hearing officer, that is the agency or the managed care entity's evidence. That's what they're going to use to try and win the fair hearing. So that is the evidence that they've submitted, that they have to submit, and that they also think is helpful to them. The case file is going to have additional information. So I know we had some questions. So let's take a nursing case, for example. The evidence packet is going to have the most recent request for private duty nursing and the denial or reduction, and then the regulations or rules that they think support that decision. It'll have the request, the plan of care, and all that information. The case file will have all of the prior requests for private duty nursing. This is true with MDCP. It would have the prior assessments for MDCP that were approved for eligibility. So that's why these are important, because you can show the hearing, otherwise the hearing officer is looking at this request for nursing came in, it got reduced or denied. You can show them, hey, here's 6 prior requests for private duty nursing that look essentially the same. My child's condition is essentially the same. The plans of care are essentially the same. I don't understand why the reduction is occurring. So those are the kind of documents in the case file that you're going to want to see. So you write the hearing officer a letter. You say, I need a continuance, I need more time, I need a new hearing date, and by the way, I'm entitled to the case file. I need the Texas Medicaid to send me my child's case file before the hearing. And if you don't get it, then you can ask for another continuance and another continuance till you get it. But in that, you can show prior approvals for the same amount of nursing or prior eligibility findings. So it's very important, the case file versus the evidence packet. But the evidence packet is what the agency or the health plan is going to use to try to win the hearing and uphold their decision.
Okay, options after reviewing the evidence packet. Now, the example we use here is, what if the evidence or the denial letter that you receive focuses on an issue that maybe could be corrected before a fair hearing or with a re-request. Sometimes in a physical therapy case, maybe the goals weren't written correctly, and the managed care organization pointed that out in their denial letter. Should you go to the fair hearing? Well, that it all depends, of course. You could withdraw, and try to fix the issue, but that might not be a good idea, because the fair hearing that you're requesting may be keeping continued services in place during the fair hearing process. And if you withdraw, then you lose those continued services. Say it was a reduction from 3 times a week for physical therapy to 1 time a week of physical therapy. Then you go down to 1 time a week of physical therapy while the therapy agency fixes the issue and tries to re-request. What you could also do is just ask for a continuance, get a new fair hearing date while the physical therapist fixes the issue, and then maybe it can get resolved before the fair hearing date. And then if it gets resolved and you withdrew your request for the fair hearing, then you don't lose the continued services, because perhaps the physical therapy provider fixed the issue and you're back to 3 times per week approved by the managed care organization. So you kind of have to figure that out on whether or not you want to go forward with your fair hearing and the timing of trying to fix the issue before the fair hearing.
Okay, so the MDCP evidence packet and case file. The evidence packet will contain the STAR Kids Screening and Assessment Instrument, or the SKSAI. Most parents often remember that visit that they have, but have never physically seen the form. So what we have seen from our clients with MDCP is that they'll notice errors or omissions in their child's SKSAI, which it will be important for you to comb through that assessment and either highlight or note where all the errors or omissions are, so you can use that and bring that up at fair hearing. Also, which will be included in the information that's provided after this presentation, there are certain sections that TMHP looks at, and we have a paper that has all those sections that TMHP utilizes to make their determination, because the SKSI form itself has many sections, but not all of them are focused on in terms of finding medical necessity. There are certain sections, and those sections should be your focus, especially if in those sections you see errors or omissions. As Peter mentioned, the case file will contain the past assessments. Just one kind of caveat that we have seen in preparing these types of cases, the DADS nurses that had done that, or excuse me, was doing the assessments prior to the MCOs doing them, they might have included, I guess, just bad notes, or they copy and paste throughout the years, even though your child's condition might have changed a little in terms of their needs. So that's something you'll have to look at and consider if you're thinking, should I include the past assessments or not? Sometimes the information will be accurate, and it is a decision that you will include all of the past assessments. But if you see those issues, so if you have your child who had seizures or very early on in life, but as he or she aged, their seizures were no longer a problem, but that was included throughout each assessment that your child was continuing to have seizures when that wasn't the case because the DAD nurse just copy and pasted, then that might be something you could potentially have to address at fair hearing if you included those past assessments. For the PDN evidence packet, again, you will see things that you might have already seen in terms of the prior authorization request that you might have signed with the nursing agency. So a lot of parents, when they see that evidence packet, they'll think, well, this is a lot of things I've already seen or I've already reviewed, especially if there's nursing notes also included. But the prior authorization request, plan of care, nursing addendum are all things you might have seen, and that will be included in the evidence packet. But again, it should include information that the nursing agency might have sent in during the appeals process. So during that internal appeal, your nursing agency might have submitted, let's say, 2 weeks worth of nursing notes, letters from your doctor if they had the opportunity to request those, and maybe MARS, the medication administration, seizure logs, all that information. And that should be included in your evidence packet. If it's not, it might come out in your case file, which again stresses the importance of requesting and reviewing the case file, because if it's in the case file but not in the evidence packet, then the fair hearing officer won't have the opportunity to review that information. It should be included if it was sent in during the internal appeal process, because it went into their final determination, but we have seen where it hasn't been included, especially with the newer managed care organizations. I think we've seen that issue with Aetna, where the agency said they submit information during the appeals process, but it was not included in the evidence packet itself. Again, we have stressed the importance of the Phoenix notes, to look at them and see if you can gauge a little bit better why they made their determination, whether it be the reduction or the denial. Also, it's important to look at and review the actual regulations and rules that they include in their evidence packet. Certain MCOs, managed care organizations, will have their own guidelines, and sometimes their guidelines are extremely bad because they will include links and access to information that they won't include. So for example, we've seen that with Aetna. They'll include this 3-page PDN guideline that looks like it's hyperlinked to other information, but you don't have that information. So it prevents you from knowing, well, what is this definition, or what is that book or article they're citing that we can't see, and it does pose a problem, and something you can bring up to the fair hearing officer, that the guideline is lacking of the additional information.
Now, gathering your evidence for the fair hearing, this is when you start to build your evidence. Consider requesting some of these documents to start building your case for your child. progress notes and test results and medical history from your child's primary care physician or other specialist, pulmonologist, gastroenterologist, neurologist, all of those different ologists. You want to make sure that you get, at least within the last 6 months to a year, any good information from those doctors. You may request medical documentation about emergency room visits or hospital stays. That kind of information would be compelling for a hearings officer to see. And, you may get some additional information from the nursing provider or the therapy provider that wasn't looked at by the managed care organization in coming up with their denial or reduction decision. That may be nursing notes. For whatever reason, some managed care organizations are just failing to look at nursing notes before they actually make a denial decision. So you may be able to get some of those nursing notes and have them in a packet that you put together that shows, look, the managed care organization is incorrect. See, this is all that's being done for my child. Seizure logs, suction logs, medication administration records. And then consider getting letters of medical necessity or support from your child's doctors and specialists. That kind of information could be compelling to rebut the managed care organization's denial or reduction. You want to review all the evidence that you are thinking about using as it comes into you. After you request it, you get it, you review it, and you review your letters of medical necessity. We all know sometimes doctors don't have a lot of time to do a good job on some of those letters of medical necessity. You may get something that's kind of lacking. You may get something that's a small paragraph that just says what the diagnoses are. It's not really helpful. It doesn't really, add a lot to your child's case. We suggest that you use that as a litmus test for determining what documents you're going to include in your evidence packet. I mean, does it add something? Does it add information not already presented somewhere else? I mean, resist the temptation to just include information just for the sake of including it in your hearing packet. If it doesn't help or doesn't add anything or it's repetitive, consider leaving it out. You don't want to drown out all your impactful documents with stuff that doesn't really add to your child's case. So keep that in mind when you're putting together your own evidence packet. Be organized, and if you're awaiting additional documents, we're going to discuss that, like Hillary said earlier, you can ask that the fair hearing be, kept open for a certain amount of time while you wait for those documents after the fair hearing, and can send them into the hearings officer for their review.
This is Peter. We just had a few questions, and I just wanted to clarify. The PowerPoint and other materials are going to be available after the presentation to download, because I know we're giving you a lot of information in a short time. So there's going to be the PowerPoint, there's the prior presentation about what to expect at a fair hearing, there's a checklist, and there's some sample letters of medical necessity, sample letters to hearing officers, things like that. So that'll all be available for you to have. I guess the first thing we do when we're thinking about our evidence or evidence we're going to use in support of the child's case, letters from the physicians and specialists are probably the most important, and we start on those early because, trying to get doctors to write or sign letters, that takes time. And so, but like Terry said, if you're at the hearing and you're waiting on a swallow study or a letter from a doctor, you can ask to keep the record open and get that added in later. But we'll talk about that in a little bit.
Right. This is a slide specific to preparing for a private duty nursing fair hearing. These are important points, important things to look at. You need to, understand the definition of professional nursing, which is in the Texas Occupation Code, and we have a link there that talks about professional nursing. The things that are included in that are assessment, interventions, medication administration. Also, understand what the definition of correct or ameliorate means. That's the medical necessity criteria for private duty nursing in Texas. The managed care organizations like to forget that. The information that is in Chapter 363 of the Texas Administrative Code about private duty nursing services, there's a lot of helpful information there as well. A lot of what's in that Texas Administrative Code rules were taken out of a settlement agreement that Peter Hoffer worked on for 15 or 16 years, Alberto N. Many of you have heard of it. A lot of that information from the settlement agreement was placed in these Texas Administrative Code rules at Chapter 363. Good information about, span of time that the managed care organization has to approve the services that occur over the span of time, that the nursing occurs over the span of time in a 24-hour day. So if the nursing services occur over an 8-hour period, then they should be receiving 8 hours per day of nursing. There's information about, the PDN definition, and that there's good information in there about what HHSC can't do or the managed care organization can't do. And one of those main points is they can't reduce private duty nursing if there's been no decrease in the nursing needs, your child's nursing needs. So that's good information to point out to a hearings officer that maybe the managed care organization didn't take those things into consideration. Also, the PCAF manual, this is the manual that pertains to PCS, or attendant care for children in Texas Medicaid. A lot of times what's helpful in here is that the PCS program in the PCAF manual points out a lot of things that the PCS program considers to be nursing care. So a lot of times the managed care organization will try to say, well, that's not nursing, and they'll try to punt it to the attendant care program. But the attendant program says, nuh-uh, we have it in our manual that may be considered nursing, and usually is nursing. Oxygen administration, seizure monitoring and treatment, and nebulizer treatments, those types of things. But the PCS program has pointed out is nursing.
Okay, so review the denial notice again. This is a suggestion that I think you should take. After you start preparing your evidence packet and have all that information, it does not hurt for you to look at and see the denial notice reasoning again, or the medical director's Phoenix notes. I would suggest that when looking at the denial notice the second time, to think, especially when it comes to maybe a reduction, or even an outright denial, if there's information that they include, especially when it comes to nursing, so these typical things your child has, are they omitting anything else? So if they say it has G-tube feeds, but they don't mention assessments, the daily assessments they need, whether it be seizure assessments and the like. So there might be things that they'll state are nursing, as an example, but that there's additional things that they're just leaving out. And that's the information that you would need to get to address to the fair hearing officer. So in looking at it, just give it a quick second review and think, are there other supportive documentation that I need outside of just countering the information in the denial notice? And then also I wanted to stress the importance of, if your child has an upcoming appointment, it might help if you drafted a letter, or if they were thinking about drafting a letter, to discuss it at your child's appointment and take the time to go through what's going on with either the primary care physician or the specialist that your child is seeing, and see if they can draft a letter, maybe right there in the office, or look at something you drafted and make corrections right there and then, and it's an easier way to make sure you'll get the information that you need. So preparing your evidence packet, I think the importance is to have this cover page. You'll notice when you receive the either the managed care organizations or TMHP's evidence packet, that they'll have a cover page of the documents included in their evidence packet. And sometimes what is frustrating is that they won't have their page numbers or their documents with the number, with the page number, on the bottom. So they might say in the cover page, pages 1 through 5 is this, but they won't have something to where if you're tabbing, you can't readily figure out, well, what page is this, without looking at and counting each page until you get to the necessary page. So we stress that you need to include page numbers, so that way when you're providing testimony at fair hearing, if you're referencing a page, you can easily say on page 28 of my submission for fair hearing, and then go through the documents. That way everyone's on the same page and can be looking at it while you're actually discussing it. So create a guide, have the page numbers, and then just a quick suggestion in terms of if you're including a lot of your child's maybe progress notes or visits, consider having them in order based on date. So maybe the most recent visit, most recent information, and if you're going to need to include the past information as well, have that towards the end. Or depending on if the more important information is on the end, just consider how you might be utilizing that document in terms of how you're going to organize it.
Yeah, and this is Peter, and you're going to have to submit your evidence packet to the hearing officer, who then gets it to the managed care entity or whoever the agency, whoever's on the other side of your hearing. You don't have to do anything fancy with the page numbers. You can just take a Sharpie and write 1, 2, 3, 4, 5 on the page numbers, and the cover sheet, it just looks like an index explaining what type of documents is on what pages, but it will make the hearing go quicker if you can refer the hearing officer to, look at the approval from 2 years ago on page 15, for example.
All right, organize, organize, organize. This is a pretty apt title for these next two slides. You want to print out your evidence packet in the case file. I recommend putting them in a 3-ring binder, and so that you can, have yourself organized where you can tab things, you can get things to things quickly. Some of these files may be, if they're ever sent to you electronically, it's just too big of a file to look at and to flip through the pages on your computer. So it's a lot better if you're organized with a 3-ring binder. As part of this organization, we recommend that you prepare a 1-page outline with everything that's happened with your child's case. When you got the denial notice, when these reductions happened, when you requested the internal appeal, when that was maybe denied, when you got the final denial notice, when you asked for the Medicaid fair hearing. So you have all of that ready in case there's any questions or issues that come up during the fair hearing on those issues. Also, make sure that you have documented all of the individuals, like the players, like we talked about earlier with the medical directors, any nurses that from the managed care organization that had a hand in the denial decision. And note whether they actually come to the fair hearing. The medical directors who make the denial decision don't always come to the fair hearing. Now, that's always the case for a medically dependent children program hearing or MDCP hearing. Those TMHP medical directors have yet to show up for a fair hearing. They send a nurse to defend the denial decision that the medical director made. And so I always point that out to the hearings officer. I mean, the hearings officer knows that, but point it out and make a point of it, that the person who made the denial decision didn't even come to the fair hearing today to defend that denial decision. That's occasionally the case also in a private duty nursing or therapy case. Managed care will sometimes just send a nurse or will send a different medical director for a private duty nursing case. Point out that that medical director is not the one who made the decision in your child's case. That the person who did make the decision isn't even here to take my questions today, those types of things. And so, again, organize, organize, organize. As far as preparing your witnesses, consider who you want to testify in your fair hearing. If it's a private duty nursing hearing, maybe you'll have one of your trusted nurses for your child testify during the fair hearing about your child. Figure out who you want to testify, and then have a time before the fair hearing where you get with that person or get with the people that you want to participate with you in the fair hearing, and have a hearing prep call. You guys can discuss the theme and the theory of your case and the role everybody's going to play on your side of the fair hearing. You can role play and test out questions with your witnesses. Those questions that are designed to kind of tell your story or have the witnesses tell the story and get out the information that's important regarding your child and the need for the service that's being denied or reduced.
Okay, so in preparing for the fair hearing, as about I would say a week or 2 weeks prior to fair hearing, that's when you need to make the determination if you need more time. So as we stressed, you can ask for a continuance. So at that time, think, have you received all your documentation? Are your witnesses ready to go? Is there any issues with maybe the date and time for some of your witnesses? And see if you need that continuance. And then make that continuance at least as soon as possible, so about a week and a week and a half prior to the fair hearing, and make sure that it has been processed. Again, want to stress not to just assume because you sent in the request for continuance that it has been granted. So also during that time, you want to make sure you've received the case file and all of the documentation that you requested. And then, again, so proceeding to fair hearing, once you decide who's going to testify, you might consider the order that you want. Do you want to provide testimony first, maybe the nurse or therapist? Is the doctor going to need time to present first? And that could be a request that you might make if there's going to be a doctor present and they don't have the time to wait until it's your opportunity to provide their testimony. You can ask the hearing officer if the doctor is allowed to proceed with their testimony first. Again, we would recommend that you review all the documents prior to fair hearing again one final time. Make sure that everything that you want to address is tabbed so you can easily access it at fair hearing, and just know everything as possible about your evidence packet, their evidence packet, and know the reason for the denial so you can truly make sure that that is expressed to the fair hearing officer. It'll also help if you know the reason with the cross-examination questions that you should be preparing, and also will help just preparing you for your testimony in terms of what you need to express and get out. We also suggest that you look through the information that we'll provide after this webinar. Maybe re-review this. Look through all the information, the checklist, see how prepared you are prior to proceeding to fair hearing. Also, we would suggest, after this, we'll provide the questions, the answers to your questions. So look through that, see what other parents have asked, and make sure that if there's anything you missed, again, that you'll have the opportunity to maybe, okay, well, after looking at all the information, I think I need to request a letter from this doctor or this specialist. Go ahead and ask for that additional time and start making that request and getting all the documentation that you need. And just a quick tip for preparing for your testimony, we'd say it's better to outline exactly what you want to get across, the major points. I don't think there's such a thing as being too prepared, so it's not going to hurt for you to jot down things, maybe type it out, play with the fonts to see this is a major point that I need to make sure I get, because as prepared as you are, it happens to all of us, we can prepare and there will be things we will miss at fair hearing that we won't mention, that we'll remember afterwards. And that shouldn't be an issue if you at least can ensure to yourself that you write down, these are the major points that I have to hit. This is what I really want the hearing officer to know. So just writing that out prior to fair hearing will really help. And just be prepared to refute any reasons that they give for the denial. So again, knowing their reasoning for denial will help, because during fair hearing they might suggest a different reason for the denial. And that's something you have to be aware of and prepared to notify the fair hearing officer. Now, that wasn't included in their denial notice. We had no idea that that was the reason for the denial, and really stress that they didn't give you that opportunity to prepare because it wasn't included in their denial notice, and they shouldn't be allowed to suggest a different reason now at fair hearing.
This is Peter. I always remind parents that, and I know they'll be nervous, they're nervous even when where they're representing their child. You have to remember that of everyone on the phone call, everyone in the hearing, you know more about your child than anyone or all of those other people combined. So you shouldn't get too nervous, because you should be able to answer the questions about your child's conditions and your child's needs, because you know them best. The reason Hillary stressed knowing the reasons given the denial is that's what makes a fair hearing fair or more fair. If they say the nursing services were reduced for because there were only 4 G-tubes per day, and the evidence shows, and you can establish that there's 6 a day, and you do that, and then they say, well, it's also because of, and they come up with another reason that wasn't included, you couldn't have prepared for that other reason, and so that would render the hearing unfair, and that's why you pointed out to the hearing officer. This is what they said in their notice, this is what the documents say, it isn't going well for them, and now they want to change the reason. So you have to be aware of the reason, and that's, the reason they give, if you can discern it, that's what you need to focus on. You need to show that that isn't true. The notices aren't great, however, so sometimes it's hard to tell the real reason. The other thing, when you talk about your child, when they go first in the hearing, and it's going to be very bland, they're not going to really make your child sound like a person. It's going to be very dry about procedural things and when the request came in and when they made a decision and sort of a cursory summary of your child's conditions. The hearing officers are not lawyers and they're not medical people, so you need to give a better picture of your child, a better picture of their conditions, a better picture of their needs, a better picture of all the assistance they require or why they need the nursing or why they're eligible for MDCP. You have to paint a fuller picture for these hearing officers. They do a lot of hearings every day. So the more you can explain in more detail about everything your child's been through, even if it goes back further, we'll talk about prior surgeries, prior things they had to overcome, things they had to go through, visits to the hospital, etc. Because you have to paint a picture not only of your child's conditions and needs, but also the risks that going without whatever services at issue would pose for them. So be prepared, outline your testimony so you don't lose track, and make sure you say everything you want to say.
Right, now you've gotten all your stuff together, you've put together your hearing packet, you've sent it to the hearings officer, now it's hearing day. And here's some basics. The hearing itself is designed to be informal, and they'll say that at the beginning of the hearings officer will say that at the beginning of the fair hearing. Now there is some structure, so it doesn't completely get out of control, but it's supposed to be, not formal. It's supposed to be, somewhat. I wouldn't call it inviting, but it's not supposed to be too intimidating. It can feel intimidating, though. Remember, these hearings are almost always conducted by phone. You use the toll-free number and the hearing code to get into your conference call. Again, like Peter stressed, the hearing officer is not a lawyer or a medical professional. Don't assume they understand all of the medical conditions and issues. You'll need to explain it to them as if they've never heard this before. The Texas rules of evidence and procedure do not apply, so you don't have to worry about any of those kinds of rules. When the hearings officer starts the hearing, they start with introductions. They make sure everybody who's on the call is on the call. They verify everybody's name and role in the hearing and address. They go through those procedural, issues about the hearing process, who's going to go first, and when they're going to, come out with their hearing decision and all of that. Obviously they give a statement that the hearing is only based on the rules and processes that the agency alleges supports their action. And that they're going to review all the evidence and exhibits in making their determination. They swear in all the witnesses during the fair hearing, and then, like Peter was saying earlier, the agency goes first. Always remember who your audience is. During the fair hearing, you may be tempted to try to convince the agency that made the denial decision or the medical director at the hearing in, say, a private duty nursing hearing, that they are wrong, and you're trying to get them to admit they're wrong. Well, that's probably going to be pretty futile, because it's unlikely that the medical director is going to say in the middle of the fair hearing, you know what, you're right, I was completely wrong. That's not likely to happen. So your target's going to be the hearings officer. again, they're not a lawyer or a person with medical background. You might think that they're not going to understand everything and all the issues with your child. But, this is where you come in with your planning and all the evidence that you've put together. Like Peter was saying, the agency is not going to really, on their side of the hearing, they're not going to really talk about your child like a person. They're going to talk about them like a number or a client. But you're going to paint a better, more fuller picture for the hearings officer so they can completely understand your child and their needs and why they need the services that have been denied. You're going to go over the letters of medical necessity that you have presented, and you're going to put on the record what your own doctors have said about your child's needs. And consider for your evidence packet writing your own letter about your child and why they need the services that have been either reduced or denied. During the fair hearing, make sure that you pay close attention to the people that have come to participate in the fair hearing, especially for the agency. Write down all of the people on a piece of paper. Note who actually had any kind of role in the decision. If they didn't have a role in the decision, then you're going to make sure that that's brought up in the fair hearing. If a medical director who comes to the fair hearing didn't actually have any kind of say or didn't even make the decision, then you could have that question: Did you even review the information? Did you make the denial decision in my child's case? And then make a point that the person who did make the denial decision is not even there today to defend or take questions from you about their denial process. You can do that during your cross-examination. The evidence before all that, the evidence is going to be admitted into the record. The agency will admit the evidence that they're going to present during the fair hearing. It's usually the packet that you receive, and pay close attention as they read it into the record, so you can figure out whether they are mentioning something that you didn't receive. If that is the case, always make sure that you notify the hearings officer immediately and say, look, I didn't get that. I didn't get that evidence that they said that they sent me. And that could be grounds for the hearing to be at least postponed and reconvened for a later date while that managed care organization sends you the information they were supposed to have sent you before the hearing. Okay, now as I mentioned, Texas Medicaid will present its case first. Write down the information that they provide, especially if it's contrary to what you have provided, and then you can point those issues out when it's your opportunity to ask questions after the agency goes. Say the managed care organization puts on their case. Before you even do your side of the case, again, you can ask questions of them based on their testimony, and that's called the cross-examination. Remember, Texas Medicaid, whether it's TMHP or whether it's the managed care organization, they have the burden of proof. They have to show by a preponderance of evidence, which is more likely true than not, that that their reduction or denial was based on policy or procedure and correct. Remember, we mentioned this earlier, but always listen for new reasons for denial, because they're not allowed to do that. If that reason that they try to bring up is not in the original denial letter, then there's no way you could have ever been prepared for that and submit evidence to rebut that reason that they just come up with in the middle of the fair hearing, and bring that up to the hearings officer and not allow the managed care organization or TMHP to provide testimony on a new denial reason. Again, after they're done with their side of the case, you can ask them questions, and that's your opportunity to ask those cross-examination questions of the representative.
This is Peter, and I know we're running short on time, but I did want to mention something about cross-examination. It's difficult. It's not like it is on TV where you're going to say something and they're going to blurt out, they were wrong and your child is eligible, or they made a mistake on the nursing. And you don't have to cross-examine. You can put on your case and give your reasons why their decision was incorrect and your reasons why your child is eligible for MDCP or your child needs those nursing hours. But if you do want to ask them questions, and what makes it difficult in these hearings is you don't really know who's going to show up and you really don't know what they're going to say. So knowing all of the evidence, you know your child, so knowing all of the evidence, so if they do say something that's incorrect, you can point that out. You can point out that, you could say something like, isn't it true that my child's been getting private duty nursing at this number of hours for the past year and a half? That's correct, right? So you could get a few things cleared up in cross-examination. What you don't want to do is give them open-ended questions where they're going to just keep reiterating their reason for denying or reducing. It would be better to focus on, since you're not lawyers, it would be better to focus on your side of the case. But if you have certain questions, or you can point out, in the SKSAI, that listed diagnoses, that left out 3 of my child's diagnoses, right? Like, you can do it that way and point out some errors or say, the criteria is this, isn't that right? So you can clear up some things, but I don't think you have to do a lot on cross-examination because I don't think it's easy for parents. I think it's better to go ahead and explain to the hearing officer why your child is eligible or why they need that amount of therapy or why they need that amount of nursing. So think about that. I know we've only got 10 minutes left, so let me go to the next slide.
After you've asked, if you determine you want to ask cross-examination questions, after all of that, you have the opportunity to put on your child's case and testify, again, like Peter said, about your child. You know them best. So you talk about their current conditions, their need for the service that's been denied or reduced, the history of your child in Medicaid, what has been approved in the past. In an MDCP hearing, my child was approved for 5 years in a row, and they started out all these conditions, 5 years ago, and they still have all of the same conditions and issues. When you're doing your side of the case and you're pointing out different parts of your hearing submission and exhibits, make sure you refer to the page number so that it makes it easy for the hearings officer to find what you're looking for when they're following along. Now, after you testify, the Texas Medicaid, as you have the opportunity to ask them questions after their presentation, they have that same opportunity. And Texas Medicaid and the hearings officer can ask you questions. And so just be polite, be honest, committed to your theory and side of the case. Remember who your audience is. You're not trying to convince Texas Medicaid that they may, that they are wrong and that they should reverse. Your audience is the hearings officer. And always answer the question that's asked. Don't give any, don't answer some other, or give some other answer to another question. Just answer whatever they ask. And if you don't know, there's no harm in saying that you just don't know. Don't try to answer a question that you don't know the answer to.
Yeah, where we see that the most is if the hearing's not going well, let's say in an MDCP case, and they can't explain why they made the decision, they might ask the parent, well, you explain what your child's nursing needs are. And I usually object and say, this is the parent of the child. They don't know nursing policy. They're not nurses. They're not fluent in the nursing occupation code. That's up to you. I know about my child. I know about their conditions. I know about their history on this program. I don't know. You can say you don't know, and if you don't know, you don't know. But I wouldn't try to, if you feel they're asking you about policy or law or rule or regulation, that's really outside of what you need to know, and just say you don't know. That's not something you know. And then just add in, I don't know that, but my doctors say that my child's eligible. My doctor says these many nursing hours are needed. These have always been beneficial to my child. I can't tell you what's nursing and what's not. That's not my role.
And Peter just basically went over this next slide. So we're going to go to the slide that talks about considering providing a closing statement. I definitely recommend this. This is actually my favorite part of doing a fair hearing. You're able to give that summation of your case and why Medicaid is wrong. I mean, it's your opportunity to summarize the evidence that you presented, poke holes, summarize the holes you may have poked in Medicaid's case. Frame it the way you see it. Wrap it up with a bow for the hearings officer. Tell your story, in summary. Be cautious of, wanting to provide additional information after Texas Medicaid has given their closing statement, because you get to do a closing statement first usually, then Texas Medicaid does theirs. Unless something is clearly erroneous that they said in their closing statement, I would resist the temptation to have the last word, so to speak. Okay. Again, at the end of the hearing, you can ask for the hearing record to be kept open if there's additional evidence that you didn't have available but you're waiting on, and that you want to submit for the hearings officer's consideration. You can do that at the end of the fair hearing as well. Now, after the hearing has been closed, if the hearing record is not going to be kept open, the hearings officer will usually, sometimes at the beginning of the fair hearing, let you know what their deadline is for a hearings decision. They're going to tell you it's going to be issued in writing and sent to your address. It can be anywhere from a few weeks to a few months. I mean, typically it's 30 to 45 days, but they may make a decision before or after that deadline they give themselves. Every hearings officer is a little bit different on whether they keep their deadlines, so be aware of that. Continued services, always remember that's going to be provided until the hearings officer actually issues their denial decision. So keep on top of the managed care organizations to send those additional authorizations while the hearings officer makes the decision if that's an issue. Win or lose, you can always request the services again, or during the after you win the fair hearing, the next authorization request after that other authorization period runs out, you still have to ask for the services again. So always remember that. The fair hearing doesn't affect subsequent authorization requests for services. And every submission should always be as up-to-date as possible so that you don't have to go through a denial again, possibly. Post-hearing remedies, options for if you lose a fair hearing, okay? If it's a service, you can always resubmit, have the provider agency, if it's nursing or physical therapy or DME, you can always try to re-request the service with additional or better documentation. On the cover letter for the hearing decision that you get from the hearings officer, we'll have information about if you're not happy with their decision, you can ask for an administrative review of that decision, which is an HHSC attorney reviewing all the evidence and in theory, and the hearings officer's decision to make sure that the hearings officer followed the correct rules and made the correct decision. That's not always very successful, but it is something that a person has the right to do. If you ask for administrative review and that upholds the hearings officer's decision, then you'll have 30 days after that to request a judicial review, which is a district court in Texas in Travis County is reviewing the hearings officer's decision. A lot of times you need a lawyer for that type of procedure. I think parents could probably try to do that themselves, but it may be very difficult. In addition, there is a way to request a hearing be reopened after a hearing decision within 1 year if there was new evidence that wasn't offered at the hearing that could have affected the hearings officer's outcome or decision. So that is something that can be done. That's not an easy task as well, but it is something that parents can do if they so choose.
We did have a couple questions, and we probably have time for one or two. One was, do you write the hearing officer for continuances? Is that the only person you contact for a continuance and to get the case file? And the answer is yes. Once you're in hearing, once you get the fair hearing notice from the hearings officer, then all your requests, I would suggest, go through the hearing officer. So you tell them you want the case file and for them to ask the Texas Medicaid to get you the case file and evidence packet. It may come from, the evidence packet will probably come from the hearing officer, they request that the managed care entity or TMHP send you the case file. So you may receive it from them, but you're requesting the hearing officer to get it for you. So I send all my requests to the hearing officer because I let them know, hey, I requested it 2 weeks ago and the hearing's next week and I still don't have it, so now I need more time. Can you ask them again? So that was one question. The other one, can you request the evidence packet by contacting the MCO? The evidence packet is produced by the managed care entity or TMHP and provided to the hearings officer who sends it to you. So that's where you'll get that from. We had a lot of questions. I think we can probably answer them today and get them out today at the latest on Monday. So we will get you those. There's when the webinar ends today, there's a web page that has all the resources. That'll have the PowerPoint. You can also listen to this training again. It also gives our intake line. Terry and Hillary's email address, I think, is on the first slide if you have any specific questions that we don't answer. But I appreciate you listening in today. I know that was a lot of information. Hopefully, I think when you look at the additional resources we've provided, sample letters of medical necessity, sample letters to the hearing officers, checklists for preparing for the fair hearing, I think that'll sort of fill in some of the gaps that we couldn't get to in an hour and a half. But I really appreciate everyone calling in, and thanks to Terry and Hillary who prepare for hearings every day and are really expert in it. So I appreciate everyone for calling in. Thank you. Matt, do you have anything?
I do not. Thanks.